The certified letter arrived on a Tuesday morning in late February, and I knew before opening it that my life in Cascade Ridge HOA was about to get complicated again. I stood in my driveway in Parker, Colorado, looking up at my roof, where approximately 8 inches of packed snow still sat from the blizzard that had rolled through 5 days earlier. The temperature had barely crept above freezing, and most houses on my street looked identical, their roofs weighted down with the same white blanket. But apparently, mine was the problem. My name is Jacob Barrett, and I have been a licensed structural engineer for 15 years. I design buildings that withstand earthquakes, wind loads that would make your average homeowner lose sleep, and yes, snow loads that dwarf what currently sat on my roof. The irony of what I was reading was not lost on me. Dear Mr. Barrett, the letter began in that particular font HOA letters always seem to use, something between Comic Sans and a ransom note. It has come to the attention of the Cascade Ridge Homeowners Association Board that your property at 4782 Wintergreen Lane is in violation of Section 7.3.4 of the Community Covenants, which states that homeowners must maintain their roofs in a condition that does not pose a safety hazard to the community. The accumulation of snow on your roof exceeds safe parameters and must be removed within 72 hours, or you will face a fine of $250 per day until the violation is corrected. I read it twice, then a third time, waiting for the punchline that never came. The letter was signed by Karen Hutchins, HOA president, with her signature so elaborate it looked like she had practiced it in middle school and never moved on. I pulled out my phone and called my neighbor, Mike, who served on the HOA board until last year when he got tired of the politics. Let me guess, Mike answered. Snow letter, you got one too? Nope, just you, buddy. I saw Karen out here yesterday with her little clipboard standing in your driveway taking pictures of your roof. I figured something was coming. My roof has the same amount of snow as everyone else on the block. Actually, yours has less. I cleared mine partially last weekend and it snowed again Sunday night, so mine is probably heavier. But Karen has had it out for you ever since you voted against her proposal to ban basketball hoops. That had been 6 months ago. Karen had wanted to ban all basketball hoops visible from the street, claiming they created an unsightly suburban clutter. The vote had failed, but barely. I had been vocal about my opposition, arguing at the meeting that kids needed places to play and that a basketball hoop was hardly an eyesore compared to Karen's own front yard fountain that looked like a cherub having a medical emergency. What should I do? I asked Mike. You could clear it, take the path of least resistance, or you could fight it. But Jacob, man, these people have nothing but time and petness. They will make your life miserable. I looked up at my roof again. It was a standard gable roof with a 6-in-12 pitch, approximately 40 feet by 30 feet of coverage. I had designed it myself when I built this house 3 years ago, calculating precisely the loads it would need to handle in Colorado's climate. The snow currently resting on it weighed roughly 7,000 pounds, give or take. My roof was rated for over 30,000 pounds of snow load before approaching any structural concern. I will think about it, I told Mike. Thanks. I went inside and pulled up the community covenants on my laptop. Section 7.3.4 did exist, buried in the middle of a document that read like it had been written by a committee of people who each got to add their pet peeve. The exact wording was, homeowners shall maintain their roofs free from accumulation of snow, ice, or debris that could reasonably be considered a safety hazard to persons or property within the community. The key word was reasonably. What was reasonable? I had the training and licensing to make that determination far better than Karen Hutchins, whose LinkedIn profile I had once stumbled across revealed her background as a former retail manager at a home goods store. I spent the next hour drafting a response letter. I kept it professional, factual, and airtight. I explained my credentials as a licensed structural engineer in the state of Colorado, provided my license number, and included a brief analysis of the actual snow load on my roof versus its rated capacity. I calculated that my roof was currently bearing approximately 14% of its maximum safe load. I cited the International Building Code sections that governed snow load requirements for residential structures in our climate zone. I concluded by respectfully declining to remove the snow, as it posed absolutely no safety hazard. I printed the letter, signed it, scanned it, and emailed it to the HOA board email address listed on their website. Then I printed another copy and drove it to Karen's house, which was 4 streets over in the section of Cascade Ridge, where the lots were slightly larger and the houses slightly more pretentious. Karen answered the door in yoga pants and a sweater that probably cost more than my monthly utility bill. She was in her early 50s, with that particular haircut that seemed to be issued along with HOA board positions, short in the back and angular in the front. "Jacob," she said, her voice already taking on that tight quality I had learned to recognize. "What can I do for you?" "I wanted to deliver this personally," I said, handing her the envelope. "It is my response to the violation notice I received today." She opened it right there, and I watched her face as she read. Her expression started neutral, moved through confused, and landed on irritated. "A structural engineering license does not give you the right to ignore HOA rules," she said. "It gives me the expertise to determine what is and is not a safety hazard," I replied. "That snow is not a hazard, not even close." "The board will review your response," she said in a tone that suggested the review would be brief and unfavorable. "But I should warn you, we take these matters seriously. If you do not comply, the fines will begin on Friday." "Then I guess I will see you at the next board meeting," I said. I drove home feeling the particular mixture of righteousness and dread that comes from knowing you are right, but also knowing that being right does not always matter. I had dealt with difficult clients, contractors who cut corners, and building inspectors on power trips, but there was something uniquely frustrating about HOA politics. At least in my professional life, physics and engineering principles were the final arbiters. Here, it was whoever could muster the most votes and harbor the longest grudges. Friday came, and so did another letter. The fine was official, $250 per day starting immediately. I had until Wednesday of the following week to pay or to clear the snow. The accumulated fine would be $490 by then. I did not clear the snow. Instead, I filed a formal appeal with the HOA board, which according to the bylaws, they were required to hear within 30 days. I also began documenting everything. I took photos of every roof on my street, time-stamped and geo-tagged. I measured the snow depth on my roof using a probe I normally used for soil samples at construction sites. I created a detailed engineering report, complete with calculations, load diagrams, and safety factors. If Karen wanted a fight, she was about to get one with someone who built structures for a living and who knew how to document his case. The appeal hearing was scheduled for 3 weeks out, on a Thursday evening at the community center. In the meantime, the fines continued to accumulate on paper, though I had no intention of paying them. The snow on my roof partially melted during a warm spell, then Colorado weather did what it always does and dumped another 6 inches the following week. I received another letter, this one informing me that my total fines now stood at $1,500 and that the board was considering placing a lien on my property if I did not pay. That escalated things beyond petty harassment into something that could actually affect my finances and property rights. I called a real estate attorney named Patricia Myers, whom I had worked with on property line disputes for construction projects. They can place a lien for unpaid HOA fines, Patricia told me over the phone. But they have to follow proper procedure, and the fines have to be legitimate. If you can prove the fines were baseless, you can challenge the lien, but it is easier to fight this before it gets to that point. That is what I am trying to do. How strong is your case? I am a structural engineer. The snow on my roof is not remotely dangerous. I can prove it mathematically. But did you violate the HOA covenant as written? I paused. The covenant says I have to maintain my roof free from accumulation that could reasonably be considered a safety hazard. And they are arguing it is a hazard. They are wrong. But they are the board, and they get to interpret their own rules unless you can prove they are being arbitrary and capricious. Do you have evidence they are targeting you specifically? Every house on my street has snow on the roof. I am the only one who got a violation notice. That helps. Document everything. Get photos, statements from neighbors if you can. And at the hearing, stay calm and stick to facts. Do not let them make this personal. That last piece of advice turned out to be harder to follow than I expected. The 3 weeks crawled by. The daily fine notices kept arriving like clockwork, each one increasing my theoretical debt. I spent my evenings preparing my presentation for the appeal hearing, creating slides, printing supporting documents, and rehearsing my points. Work became a welcome distraction. I was in the middle of designing a mixed-use building in downtown Denver, and the technical challenges of integrating retail, office, and residential spaces while meeting seismic requirements actually felt simple compared to HOA politics. At least buildings followed the laws of physics. The Thursday of the hearing arrived cold and clear. I put on a suit, which probably was overkill, but I wanted to look professional. I loaded my laptop, a portable projector, printed packets of my engineering report, and a scale model of a roof truss I had built to demonstrate load distribution. The community center was a bland, single-story building that hosted everything from kids' birthday parties to senior yoga classes. The meeting room had that particular smell of stale coffee and carpet that had been vacuumed too many times without being replaced. Folding chairs were arranged in rows facing a table where the 5 board members sat. Karen was in the center, naturally. To her right was Tom Sheffard, a retired insurance adjuster who always looked like he was calculating risk premiums in his head. To her left was Diane Crawford, a woman in her 60s who had lived in Cascade Ridge since the development was built. The other 2 board members were newer, and I did not know them well. Brad something and a younger woman named Ashley. About 15 people sat in the audience, which surprised me until I realized Karen had probably encouraged people to attend. I recognized a few neighbors, including Mike, who gave me a supportive nod. Karen called the meeting to order with the kind of procedural formality that suggested she had watched a lot of board meeting videos online. We are here to hear an appeal from Mr. Jacob Barrett regarding violation notice number 2025-047, issued for unsafe snow accumulation on his roof. Mr. Barrett, you have 15 minutes to present your case. I stood and set up my projector. Thank you. I will need more than 15 minutes given the technical nature of my presentation. You have 15 minutes, Karen repeated. This is not a trial. It is an appeal of a $1,500 fine and a potential lien on my property, I said evenly. I believe that warrants a thorough presentation. Tom leaned over and whispered something to Karen. She pursed her lips but nodded. 20 minutes, not a second more. I pulled up my first slide, which showed my credentials. My bachelor's and master's degrees in structural engineering from Colorado State University, my PE license, and a summary of my 15 years of experience. I was not bragging. I was establishing that I knew what I was talking about. The violation notice I received claimed that the snow on my roof exceeded safe parameters. As a licensed structural engineer, I can state unequivocally that this is false. I advanced to the next slide, which showed the calculations for my roof's snow load capacity. My roof was designed to meet and exceed Colorado Building Code requirements for snow loads in our region. The code requires a minimum snow load capacity of 30 pounds per square foot in Parker. My roof is rated for 45 pounds per square foot, a 50% safety margin. I could see Karen starting to tap her pen against her notepad, a sign she was getting impatient. I pressed on. The snow currently on my roof, even after the recent storm, weighs approximately 12 pounds per square foot. That is 27% of my roof's rated capacity and 40% of the minimum code requirement. To put it in perspective, my roof could safely hold nearly 4 times the current snow load before approaching any structural concern. I switched to photos showing every house on my street. Furthermore, my roof has less snow than most of my neighbors, none of whom received violation notices. This suggests the enforcement is arbitrary and targeted rather than based on actual safety concerns. Karen held up her hand. Mr. Barrett, we are not engineers. We are homeowners concerned about safety in our community. Which is exactly why you should defer to someone who is an engineer when making determinations about structural safety, I replied, keeping my voice level. You would not tell a doctor how to perform surgery. You should not tell a structural engineer what constitutes a safe snow load. That got a reaction. Brad, one of the board members I did not know well, actually smiled slightly, but Karen's face hardened. The covenant gives the board authority to determine what constitutes a safety hazard, she said. The covenant says reasonably considered a safety hazard, I countered. There is nothing reasonable about claiming that snow weighing a quarter of a roof's capacity is dangerous. That is not reasonable, it is demonstrably false. I walked them through the rest of my presentation, showing the model truss, explaining how load distribution works, and providing examples of actual roof failures from snow loads. Those failures, I noted, all occurred with snow loads exceeding 80 pounds per square foot on roofs with inadequate designs, nothing remotely comparable to my situation. When I finished, I had run slightly over 20 minutes, but no one stopped me. I packed up my materials and sat down, feeling like I had made the strongest case possible. Thank you, Mr. Barrett, Karen said in a tone that suggested she was anything but thankful. The board will now deliberate. Please wait outside. I went out into the hallway with the other attendees. Mike clapped me on the shoulder. That was impressive, man. You made them look ridiculous. Let's see if it matters, I said. We waited for 40 minutes. I could hear raised voices from inside the room a few times, which I took as a good sign. If it was unanimous against me, they would have decided in 5 minutes. Finally, the door opened and Karen called us back in. Everyone filed back to their seats. Karen had a piece of paper in front of her and would not make eye contact with me. The board has reached a decision, she announced. By a vote of 3-2, the appeal is denied. The violation stands, and the accumulated fines of $2,100 are due within 10 days. My stomach dropped. $2,100. They had added more days while I waited for the hearing. However, Karen continued, and I heard Tom whisper something sharp to her. The board will suspend further daily fines if Mr. Barrett removes the snow from his roof within 72 hours. If the snow is not removed, daily fines will resume at the rate of $250 per day. I stood up. I would like to know the reasoning for this decision. The board is not required to provide detailed reasoning, Karen said. Actually, according to your own bylaws, any homeowner has the right to understand the basis for decisions affecting their property, I said. I had read those bylaws cover to cover multiple times by now. Tom cleared his throat. The board's position is that the covenant gives us discretion to determine safety hazards, and we maintain that the snow accumulation constitutes such a hazard regardless of the engineering analysis. We have to err on the side of caution for the community. Even when an expert tells you there is nothing to be cautious about, I asked. Mr. Barrett, the decision has been made, Karen said with finality. This meeting is adjourned. I gathered my things in silence, my mind already moving to next steps. This was not over, not by a long shot. If they wanted to play hardball, I would show them what that really looked like. Outside, Mike caught up with me in the parking lot. That was garbage, man. Complete garbage. Brad and Ashley voted in your favor, by the way. I could tell from their faces. 2 votes against 3. Great. You going to pay it? Hell no, I am going to sue them. Mike whistled. That is a big step. They are about to put a lien on my property over a situation that poses 0 actual danger, while ignoring the same condition on every other house. That is not just wrong, it is actionable. I drove home and immediately called Patricia Myers. She was not surprised to hear from me. They denied your appeal, she asked. 3-2. Did they provide reasoning? Basically that they have discretion and they are choosing to exercise it against all evidence and expert opinion. Patricia was quiet for a moment. Okay, here is what we do. We file a lawsuit in Douglas County District Court challenging the fine and any lien they attempt to place. We argue arbitrary and capricious enforcement, violation of their own bylaws, and if we can prove it, targeted harassment. It is going to cost you, though, probably $5,000 to $10,000 in legal fees by the time we are done. More than the fine itself. Yes, which is why most people just pay the fine. That is what HOAs count on, but if you want to fight it on principle, I am with you. I thought about it for about 10 seconds. Let's do it. Draft the complaint. I will have something for you to review by Monday. That weekend was a blur of research and documentation. I created a spreadsheet of every house in Cascade Ridge that I could photograph, noting which ones had snow on their roofs and which did not. Out of 87 houses I could document, 63 had visible snow accumulation. Only 1 had received a violation notice. Mine. I also started reaching out to neighbors, asking if anyone would be willing to provide statements about the selective enforcement. Most people were sympathetic, but nervous about getting on the HOA's bad side. Mike agreed to provide a statement immediately. Another neighbor, Susan, also agreed after I explained the situation. By Monday, Patricia had a draft complaint ready. It was 20 pages of legal argument, but the core was simple. The HOA was abusing its authority to target me specifically for reasons unrelated to legitimate safety concerns, and they were doing so in violation of their own governing documents and basic principles of fairness. We filed it on Tuesday. The Douglas County District Court stamped it, assigned a case number, and we arranged for service of process to be delivered to each board member individually and to the HOA's registered agent. I should have anticipated what came next, but somehow I did not. On Thursday, 2 days after the lawsuit was filed, I came home from work to find a new violation notice on my door. This one cited me for having a non-approved exterior color on my front door. My front door was dark blue. It had been dark blue since I built the house 3 years ago. The HOA had approved the color during the construction review process, and I had the approval in my files. I was still staring at this notice when my phone rang. It was Patricia. "Jacob, I just got a very aggressive call from an attorney representing the HOA. Woman named Linda Pritchard works for a firm in Denver that specializes in HOA litigation." That was fast. They lawyered up immediately, which tells me they are taking this seriously. Linda started with threats, said you are wasting everyone's time and money, said the HOA has every right to enforce its covenants. Pretty standard opening salvo. I told her we will see her in court. I just got another violation notice for my front door color, which was approved 3 years ago. Patricia swore. They are retaliating. That is incredibly stupid of them. Save that notice, document when you received it, and send me a copy. That actually helps our case. They are proving our point about harassment. Over the next 2 weeks, I received 3 more violation notices. One claimed my lawn had weeds, which was absurd given that my lawn was dormant and covered in snow. Another said my trash cans were visible from the street on a non-collection day. Even though they were in the same spot they had been for 3 years, and the covenant allowed trash can storage in side yards. The third claimed I had an unauthorized structure in my backyard, referring to a small garden shed that, once again, had been approved during construction. Each notice carried a separate fine. They were trying to bury me in penalties, but each notice also strengthened my lawsuit. Patricia filed an amended complaint adding a count for retaliatory harassment and seeking an injunction to stop the HOA from issuing further violations while the case was pending. The judge assigned to our case was named Harold Martinez. According to Patricia, he was fair-minded but had little patience for nonsense from either side. Our first hearing was scheduled for late March, about 6 weeks after I filed the lawsuit. In the meantime, the snow on my roof finally melted. A warm spell in early March took care of it naturally, just as I had known it would. The whole issue had been theatrical from the start, manufactured concern over a non-problem. But the principle remained, and the fines remained, and the HOA's harassment continued. They were not going to stop just because the snow was gone. The hearing on the injunction arrived on a cold Wednesday morning. The courthouse in Castle Rock was busy, and our case was one of several on Judge Martinez's docket. We waited in the hallway until called, and I finally got to see the HOA's attorney in person. Linda Pritchard was in her 40s, professional and polished in a way that suggested she did this kind of work all the time. She greeted Patricia with cool professionalism and ignored me entirely. When we were called into the courtroom, Judge Martinez looked at the file with the expression of someone who had seen every flavor of nonsense the legal system had to offer. "All right," he said. "This is a motion for preliminary injunction to prevent the HOA from issuing further violation notices to Mr. Barrett while the underlying case proceeds. Miss Myers, you want to tell me why I should grant this?" Patricia stood. "Your Honor, the HOA has issued 6 separate violation notices to Mr. Barrett in the last 3 weeks, all of them for conditions that either do not exist, were previously approved, or have been present for years without issue. This is clearly retaliatory given that the notices began immediately after Mr. Barrett filed suit challenging their initial violation notice for snow on his roof. Miss Pritchard, what is the HOA's response?" Linda Pritchard stood smoothly. "Your Honor, the HOA has a duty to enforce its covenants consistently. The fact that Mr. Barrett has multiple violations is evidence of his general disregard for community rules, not evidence of retaliation. Multiple violations that were not violations until he sued you, Judge Martinez observed dryly. The HOA regularly reviews properties for compliance, Linda said. Mr. Barrett's property received additional scrutiny after his refusal to comply with a legitimate safety directive. A safety directive that he, as a licensed structural engineer, says was baseless, Patricia interjected. Judge Martinez held up his hand. I have read the file, counsel. Miss Pritchard, I have to say, this looks pretty retaliatory from where I sit. 6 notices in 3 weeks, all after the lawsuit was filed. Correlation is not causation, Your Honor. No, but it is pretty suggestive. Here is what I am going to do. I am granting a limited injunction. The HOA will not issue any further violation notices to Mr. Barrett until we resolve the underlying case, unless the violation constitutes an immediate safety hazard or legal violation, in which case the HOA will notify the court and Mr. Barrett simultaneously. Any violation of this order will result in sanctions. Clear? Yes, Your Honor, Patricia said. Linda Pritchard looked like she had bitten into something sour but nodded. Yes, Your Honor. Good. Now let's talk about the main case. Miss Pritchard, you want to tell me why your client fined Mr. Barrett for snow on his roof when he is literally a structural engineer who says it was safe? Your Honor, the HOA's covenants give the board discretion to determine safety hazards. Mr. Barrett's credentials do not override the board's authority. Do they not, though? Judge Martinez said. If a doctor lived in this HOA and the board decided his medical practices were unsafe, would the board's opinion override the medical board's licensing of that doctor? That is not analogous, Your Honor. Seems pretty analogous to me, but we will save that for trial. When can everyone be ready? We scheduled a trial date for early June, about 2 months away. It felt simultaneously far away and coming up too fast. Leaving the courthouse, Patricia was cautiously optimistic. Judge Martinez is clearly skeptical of the HOA's position. That is good for us, but we still have to prove our case at trial. What do we need? More evidence of selective enforcement. Any documentation you have of prior conflicts with the board president, and expert testimony if possible. Do you know any other structural engineers who could review your analysis and back you up? Several. I can get someone. Over the next weeks, I built our case. I reached out to colleagues, and a structural engineer named Richard Park agreed to review my analysis and provide expert testimony. Richard had 30 years of experience and had literally written sections of the Colorado Building Code amendments. If the HOA wanted to question structural engineering expertise, they were about to get a masterclass. I also did some digging into Karen Hutchins and the HOA board's history. What I found was illuminating. Over the past 3 years that Karen had been president, the HOA had issued violation notices at 3 times the rate of the previous administration. They had also been sued twice before, both cases settling quietly before trial. One was for discriminatory enforcement, the other for exceeding their authority in denying a homeowner's modification request. The HOA had a pattern of overreach, and I was just the latest person to push back. As the trial date approached, I also learned something interesting through the pre-trial discovery process. Patricia had subpoenaed the HOA's meeting minutes and correspondence, and buried in the emails was a chain between Karen and Tom discussing me specifically. Karen had written 3 days before issuing my snow violation notice. Jacob Barrett continues to be a problem at meetings, always arguing against reasonable proposals. We need to find a way to make him fall in line or make his life difficult enough that he moves. Tom, can you find a violation we can hit him with? Tom's response. I will review his property. Everyone has something. Patricia nearly jumped out of her chair when she found that email. This is it. This is proof of targeted harassment. They were looking for anything to violate you with, and they settled on the snow because it was winter and they thought you could not fight back on it. Can we use this at trial? Absolutely. This is gold. The trial began on a Tuesday morning in early June. The weather had turned warm and pleasant, with aspens leafing out and the Colorado skies that perfect shade of blue that made you forget the state could bury you in snow 3 months earlier. The courtroom was smaller than I expected, and less dramatic. No jury, just Judge Martinez at his bench, the 2 legal teams at their tables, and a smattering of people in the gallery including Mike, Susan, and to my surprise, several other neighbors who had heard about the trial. Patricia gave our opening statement, laying out the facts cleanly. I was a structural engineer with expertise to determine roof safety. The snow was objectively not dangerous. The HOA singled me out among dozens of houses with identical conditions, and they did so as part of a pattern of harassment that began when I opposed the HOA president's proposals at meetings. Linda Pritchard's opening was what I expected. The HOA had authority under the covenants. They were exercising that authority in good faith, and my refusal to comply showed a disregard for community governance. Then the evidence phase began. Patricia called me first. I walked through my credentials, my analysis of the snow load, and the photos showing selective enforcement. Under Linda's cross-examination, she tried to make me seem arrogant, someone who thought his expertise meant he did not have to follow rules. Mr. Barrett, do you believe you are above the HOA rules because you are an engineer? She asked. No. I believe I am capable of accurately assessing whether snow on my roof is dangerous, and I believe the HOA was wrong to claim it was. But you understand that HOAs exist to maintain community standards. I understand they exist to enforce reasonable covenants. I do not believe it is reasonable to fine someone for a condition that poses no actual risk. So you get to decide what is reasonable. When it comes to structural engineering, yes. Just like I would defer to a doctor on medical questions or a lawyer on legal questions. Expertise matters. Patricia called Richard Park next. He was everything I hoped, calm, authoritative, and utterly convincing. He reviewed my analysis, confirmed it was correct, and explained to Judge Martinez in clear terms why the snow load was safe. Your Honor, Richard said at one point, if the snow on Mr. Barrett's roof was dangerous, then every house in Parker was dangerous that week. The entire metro area would have been at risk. That was not the case. This was a normal snow accumulation, well within design parameters. Under cross-examination, Linda tried to suggest there was some uncertainty in the calculations, but Richard shut that down. Engineering is not guesswork, counsel. We use established formulas, tested materials, and known loads. Mr. Barrett's roof was safe. That is not an opinion, it is a fact. The emails were entered into evidence next. Patricia walked through the exchange between Karen and Tom, highlighting the damning language. Make him fall in line or make his life difficult enough that he moves. That phrase hung in the courtroom like smoke. Linda objected, claiming the emails were taken out of context, but Judge Martinez overruled her. Counselor, this seems pretty in context to me. Your client's board president literally wrote about targeting Mr. Barrett. How is that out of context? The HOA called Karen as their main witness, which turned out to be a mistake. Under direct examination, she tried to portray herself as a concerned community leader just trying to keep everyone safe. But under Patricia's cross-examination, she fell apart. "Miss Hutchins, how did you determine that the snow on Mr. Barrett's roof was dangerous? It looked like a lot of snow. Did you measure it? No. Did you consult any engineering references?" "I did not need to. It was clearly excessive." "Clearly excessive to you, a former retail manager with no engineering background." "Objection, argumentative," Linda said. "Sustained, but barely," Judge Martinez said. "Miss Myers, ask questions." "Miss Hutchins, how many other houses received snow violation notices in February?" "I do not recall exactly. Let me help you. The answer is 1, Mr. Barrett's. Is that correct? He had the most snow, did he? Because we have photos showing his roof had less snow than several neighbors." Karen shifted in her seat. "We cannot monitor every single house." "But you specifically drove to Mr. Barrett's house to photograph his roof, did you not? You targeted him." "I was doing my duty." Patricia pulled out a printed copy of the email. "Is this your email, dated February 17th, in which you wrote, 'We need to make him fall in line or make his life difficult enough that he moves'?" Karen's face flushed. "That was a private email taken out of context." "What context makes that appropriate?" "Mr. Barrett has been disruptive at meetings." "Disruptive how?" "He argues against proposals." "He votes and speaks at meetings, which is his right as a homeowner, correct? He does it in a confrontational way." "So you decided to retaliate by finding violations to charge him with, as you wrote in your email." "That is not what I meant." "What did you mean?" Karen did not have a good answer. She stammered through a non-response about community standards and responsibility, but the damage was done. Judge Martinez was watching her with the expression of someone who had heard enough. Tom was called next and tried to walk back the emails, claiming they were just venting and not actual policy. But his testimony contradicted Karen's in small ways that made both of them look less credible. The trial lasted 2 days. On the morning of the 3rd day, Judge Martinez called us back for his ruling. "I have reviewed all the evidence and testimony," he began, "and I am ruling in favor of Mr. Barrett on all counts." The HOA's violation notice for snow accumulation was baseless, arbitrary, and issued as part of a targeted campaign of harassment. The subsequent violation notices were clearly retaliatory. The fines are vacated in their entirety. The HOA is enjoined from placing any lien on Mr. Barrett's property, and the HOA will pay Mr. Barrett's reasonable attorney fees and costs. I felt a wave of relief so strong I almost laughed. Patricia squeezed my arm. "Furthermore," Judge Martinez continued, "I am troubled by the evidence of the HOA board's conduct. The emails presented show a deliberate intent to harass a homeowner for exercising his rights to participate in community governance. That is not acceptable. I am ordering the HOA to implement a training program for all board members on proper enforcement procedures and homeowner rights, to be completed within 90 days, with proof of completion filed with this court." Linda Pritchard stood. "Your Honor, the board members are volunteers. Ordering training is unduly burdensome." "Then they should not have abused their positions," Judge Martinez said flatly. "If they want the authority to fine homeowners and place liens, they need to understand the legal limits of that authority. The order stands." He banged his gavel and it was over. Outside the courthouse, Patricia was beaming. "That went as well as it possibly could have. You will get your attorney fees, which will probably be around $8,000, and you are completely off the hook for the fines." "What about Karen and the board?" "The judge's order for training is actually significant. It puts them on notice that they are being watched. If they retaliate again, you can bring them right back to court and the penalties will be much worse." I shook her hand, thanked her profusely, and headed to my car. Mike had been in the courtroom and caught up with me in the parking lot. "That was awesome, man. Did you see Karen's face when the judge vacated the fines?" I was trying not to gloat too visibly. "What happens now?" "I go home, enjoy the fact that I do not have to deal with this anymore, and hope Karen learns her lesson." Mike laughed. "People like Karen never learn, but at least now she knows you will fight back." The HOA issued a brief statement to the community the following week, summarizing the court's decision in the most neutral possible terms and announcing the upcoming board training. There was no apology, no acknowledgement of wrongdoing, just the bare facts. I did not care. I had won, and that was enough, but the story did not quite end there. About a month after the trial, I got a call from Mike. "Dude, you are not going to believe this. Karen resigned from the board." "Really?" "Yeah, she sent an email to everyone last night. Said she was stepping down for personal reasons. But I heard from Diane that there was a special meeting where several homeowners demanded her resignation after the court case. Diane voted to ask her to leave, and Tom did too. She did not have support anymore. Who is taking over as president?" "Diane, for now. And she already sent an email saying the board is going to review enforcement procedures and focus on actual community issues instead of nitpicking. It is like a whole new world." Things did change after that. Diane was a fair and reasonable board president. Violation notices dropped to a trickle, and when they were issued, they were for legitimate concerns like someone's tree actually damaging a fence or an actual safety hazard like an unsecured trampoline. I continued to attend meetings occasionally, mostly just to stay informed. Without Karen's constant proposals for new restrictions, the meetings became shorter and less contentious. The attorney fees the HOA was ordered to pay me came to $7,800, which covered most of Patricia's bill. I considered it a win, not just financially but as a matter of principle. HOAs need oversight, and homeowners need to know they can push back against abuse of power. My roof performed exactly as designed through the next winter, and the winter after that, and every winter since. When we got hit with a particularly heavy snow in late January a couple years later, someone at an HOA meeting joked that we should ask me to inspect everyone's roofs for safety. I offered to do exactly that, pro bono, and several people took me up on it. Everyone's roof was fine. Karen moved out of Cascade Ridge about a year after resigning from the board. I heard through the neighborhood grapevine that she and her husband were downsizing. I did not know if the HOA debacle played a role in that decision, and I did not ask. I still live in my house, with my blue front door and my properly engineered roof. My basketball hoop is still in the driveway, and kids from the neighborhood still come by to shoot hoops sometimes. The whole experience taught me something important. Fighting back against unreasonable authority is not just about winning, it is about setting a precedent. After my case, other homeowners in Cascade Ridge felt empowered to push back when the HOA overstepped. The board became more cautious, more reasonable, because they knew they could not just bully people into compliance. And every winter, when the snow falls and accumulates on my roof, I look up at it with satisfaction, knowing it is exactly where it should be, perfectly safe, and that I do not owe anyone an explanation or a dime for it being there. The structural engineering license I had worked so hard to earn turned out to be useful in ways I never expected. Not just for designing buildings, but for defending my home and my rights against petty tyranny disguised as community governance. I framed Judge Martinez's order and hung it in my home office, right next to my engineering license. Visitors sometimes ask about it, and I am always happy to tell the story. It serves as a reminder that expertise matters, that standing up for what is right is worth the effort, and that HOAs, for all their power, are not above the law. The thing about being an engineer is that you learn to trust facts, calculations, and the laws of physics. Those things do not care about politics or personal grudges, or who has the most authority in an HOA meeting. Snow loads are snow loads. Structural capacity is structural capacity, and no amount of Karen's clipboard wielding could change those realities. In the end, that is what saved me. Not just my willingness to fight, but the fact that I had objective, irrefutable proof that I was right. The math does not lie, and when you can prove something mathematically, no amount of bureaucratic nonsense can overcome it. I sometimes wonder what would have happened if I had just paid the fine, if I had cleared the snow and accepted the injustice for the sake of peace. I probably would have saved some time and stress in the short term. But I also would have validated Karen's abuse of power and set a precedent that homeowners should just comply rather than question authority. That was not acceptable to me then, and it is not acceptable to me now. When institutions overstep, someone has to push back. Sometimes that someone is a structural engineer with too much stubbornness and too much documentation. The legal battle lasted months, cost thousands of dollars in attorney fees, and consumed countless hours of my time. But it was worth every minute and every penny. Not just because I won, but because the community became a better place afterward. The board became more accountable. Homeowners became more engaged. The whole dynamic shifted from authoritarian to collaborative. Diane's leadership as board president made a real difference. She instituted open forums where homeowners could raise concerns before they became violation notices. She created a process for reviewing enforcement decisions to ensure they were fair and consistent. She even established a committee to review and update the outdated covenants, removing some of the more absurd rules that had accumulated over the years. The basketball hoop ban never came up again. Neither did proposals about regulating front door colors or restricting garden sheds or any of the other petty restrictions Karen had championed. Instead, the board focused on things that actually mattered: maintaining common areas, organizing neighborhood events, and addressing real safety issues when they arose. I got involved with the Covenant Review Committee and helped rewrite Section 7.3.4, the snow accumulation rule. The new version required the board to consult with qualified professionals before issuing any violation notice based on structural or engineering concerns. It was a small change, but an important one. Future homeowners would not face what I faced. My relationship with my neighbors strengthened through the whole ordeal. Mike and I became closer friends, bonding over our shared frustration with HOA politics. Susan and several others who had been quietly unhappy with the board's behavior felt emboldened to speak up at meetings. The neighborhood became more cohesive, ironically, because of the conflict. I even reconciled, to some extent, with Tom. He approached me at a community barbecue about 6 months after the trial and apologized. "I should have pushed back on Karen more," he said. "I knew she was targeting you, and I went along with it because it was easier than fighting her. That was wrong." I appreciated the apology. Tom was not a bad person, just someone who had gone along with a bad leader. He resigned from the board a few months later, saying he wanted to focus on other things. I believed him. The training program Judge Martinez ordered turned out to be more substantial than I expected. The HOA hired a law firm specializing in HOA governance to conduct a full-day training session for all board members. They covered topics like fiduciary duty, fair enforcement, due process, and the legal limits of HOA authority. Deanne told me afterward that it was eye-opening for everyone, even for her, and she was one of the reasonable ones. As time passed, the whole incident became part of neighborhood lore. New residents moving into Cascade Ridge would hear about the engineer who sued the HOA, and sometimes seek me out to hear the story firsthand. I became known as someone who would not be pushed around, which had the interesting effect of making the board extra careful in any dealings with me. I never received another violation notice, not even for legitimate issues. One winter, a few years after the lawsuit, we got hit with a particularly heavy snowstorm that dumped nearly 2 feet on the metro area. My roof, of course, was fine. But an older house 3 streets over, one built before current code requirements, developed a concerning sag in the ridgeline. The homeowners were elderly and did not know what to do. Diane called me. "Jacob, could you take a look at the Henderson house? I am worried about their roof, but I do not want to issue a violation notice without knowing if it is really a problem." I grabbed my gear and headed over. The roof was indeed concerning. The older structure was not rated for the snow load we had received, and the sag indicated the framing was overstressed. I did some quick calculations and determined that while it was not in immediate danger of collapse, it needed to be cleared soon, and the structure likely needed reinforcement. I explained this to the Hendersons and helped them find a contractor to clear the snow and another to assess the framing. The HOA actually voted to provide some financial assistance for the repairs, since it was a safety issue. The whole situation was handled exactly right, with expertise consulted, real concerns addressed, and homeowners treated with respect. That was what HOAs should do, what they could do when run by reasonable people focused on community welfare rather than personal agendas. My career continued to flourish. The mixed-use building in Denver was completed and won a design award. I took on more complex projects, including a hospital addition that required intensive seismic design and a high-rise residential tower in Colorado Springs. Each project reinforced the same principles I had relied on in my HOA battle. Trust the math, document everything, and do not let anyone bully you into accepting substandard work or unreasonable demands. I sometimes gave talks at engineering conferences about the HOA case, usually framing it as an example of how engineers need to be prepared to defend their professional judgment, even in unexpected contexts. The story always got laughs and nods of recognition from other engineers who had dealt with similar situations. My blue front door faded slightly over the years from sun exposure, so I repainted it. I chose the exact same shade of blue, and this time I did not even bother submitting it for approval. No one said a word. The garden shed that had been declared an unauthorized structure during the harassment campaign remained exactly where it was, housing my lawn mower, tools, and camping gear. It was still perfectly legal, just as it had always been. Life in Cascade Ridge settled into a comfortable rhythm. The HOA functioned as it should, mostly invisible until needed for actual community issues. Violation notices became rare and reasonable. Meetings became shorter and friendlier. The neighborhood thrived. I stayed involved enough to keep an eye on things, but not so involved that it consumed my life. I voted in board elections, attended a few meetings each year, and stayed informed about proposed rule changes. But mostly I just lived my life, enjoying my home and my neighborhood without the constant threat of harassment. Looking back, I am glad Karen issued that first violation notice. Not because I enjoyed the stress or the legal battle, but because it forced a reckoning that made the community better. Sometimes conflict is necessary to create change. Sometimes standing up to unreasonable authority is exactly what needs to happen. And sometimes being a structural engineer is not just about designing buildings, but about having the knowledge and confidence to defend what is right when everyone around you is wrong. My roof stands strong, engineered to withstand far more than a Colorado winter can throw at it. My home is mine, free from the burden of unjust fines and the threat of baseless violations. And my community is better for the fight that happened, even though no one wanted it at the time. That is the thing about fighting back. You never know how it will turn out, but sometimes the risk is worth it. Sometimes you win not just for yourself, but for everyone who comes after you. Sometimes one person standing up makes all the difference. And sometimes the person who stands up just happens to be a structural engineer who knows exactly how much snow a roof can safely hold, who has the credentials to prove it, and who is stubborn enough to fight a 2-month legal battle over a principle. I would do it all again in a heartbeat. Not because I enjoyed it, but because it was right. And in the end, that is what matters most.